Good morning, this is your Kelso Report for Friday, February 8th, and I'm your host, Clark Kelso. We begin today with a reminder that in suits against the federal government, you'd better double-check the jurisdictional statutes to make sure you're filing in the right court. In particular, suits involving veterans' benefits go to the Court of Appeals for veterans' claims, not the district courts. The Supreme Court of California has affirmed another death penalty, and they also give us an interesting case about remedies in an employment discrimination context. And we close today with a case involving a punitive damage claim against a healthcare provider and the special rules that apply there. Well, let's begin with the Ninth Circuit. One of the challenges in suing the federal government is properly identifying which court has jurisdiction. Because of the doctrine of sovereign immunity, the federal government can be sued only if it gives its consent. And part of that consent usually channels litigants to particular federal courts. Many claims, for example, must be brought only in the Federal Court of Claims. Others may be brought in a local United States District Court, and some must be filed with a federal circuit. Well, in Recinto v. United States Department of Veterans Affairs, the Ninth Circuit reviewed a lawsuit asserting due process and equal protection violations against the Department of Veterans Affairs benefit program. The plaintiffs were a group of Filipino World War II veterans and their widows who did not receive payments under the Filipino Veterans Equity Compensation Fund, a fund established by statute in 2009 to give a one-time payment to each qualifying service member. These particular veterans and their widows either were ineligible for benefits under the statute or qualified for benefits, but were denied them because the department could not verify their military service. Now, as a general matter, benefits decisions made with the department are reviewed first internally by the VA's Board of Veterans Appeals. That's how you exhaust the administrative remedy. Then, according to the Veterans Judicial Review Act of 1988, appeals of benefit determinations may be made to a special Article I court known as the United States Court of Appeals for Veterans Claims, which has exclusive jurisdiction to review decisions of the Board of Veterans Appeals. Appeals from that court go to the Federal Circuit and then to the United States Supreme Court by way of cert. The Ninth Circuit ended up with the appeal in this case because the plaintiffs sought to characterize their claims as something other than an appeal of a denial of benefits, and so they filed suit in a California federal district court. Presumably they thought a more favorable forum. The Ninth Circuit panel rejected the due process claim on jurisdictional grounds, concluding that the due process claims could not be considered without getting into a review of individual benefit decisions. And exclusive jurisdiction for that type of review was placed with the Court of Appeals for Veterans Claims. The panel decided that the equal protection claim could be resolved simply by consulting the face of the statute, without diving into individual benefit decisions. So the panel considered that claim, but found against the plaintiffs on the merits. The Filipino Veterans Equity Compensation Fund provided for a lesser amount of compensation for Filipino veterans than for United States Armed Forces veterans. Now that may sound like a form of discrimination based on race or nationality, but you have to remember that the Philippines are a U.S. territory, and according to the Ninth Circuit, the fund's discrimination was on the basis of territory status, not on the basis of race or nationality, and it therefore triggered only rational basis scrutiny. Well, under that standard, the lower benefits could easily be justified simply as a way of conserving resources for U.S. Armed Forces veterans who Congress determined should receive preference. Plaintiff's equal protection claim was therefore rejected. Bad day for the plaintiffs in that case. Next, we have a death penalty case from the Supreme Court of California in People v. Williams. The California Supreme Court unanimously affirmed yet another death penalty. This time, the defendant was convicted of the first-degree murders of two people with special circumstances of multiple murder and murder in the commission of burglary and robbery. The jury also found the defendant personally used a firearm in both murders. Naturally, the defendant was also convicted of 2 counts of first-degree robbery and 1 count of first-degree burglary. It took the court, frankly, a rather brief 47 pages, that's not a very long opinion in a death penalty case, only 47 pages to affirm the conviction and sentence. The court also issued an important remedies decision in an employment discrimination context. Now, a rather common factual defense in employment discrimination cases is to assert that even if the plaintiff had been subjected to some degree of discriminatory treatment, the employer also had perfectly legitimate, non-discriminatory reasons for taking the adverse employment action complained of by the plaintiff. The problem is essentially one of mixed causation, a topic that courts often struggle to accommodate to the all-or-nothing nature of courts and civil judgments. In Harris v. City of Santa Monica, the California Supreme Court dealt with a case where a bus driver alleged that she was fired by the city because of her pregnancy in violation of the Prohibition on Sex Discrimination in the Fair Employment and Housing Act. The city claimed she had been fired for poor job performance. At trial, the city asked the court to instruct the jury that if it found a mix of discriminatory and legitimate motives, the city could avoid liability by proving that a legitimate motive alone would have led it to make the same decision to fire her. Well, the trial court refused that instruction, and the jury returned a substantial verdict for the employee. The Court of Appeal reversed, holding that the requested instruction was legally correct and that refusal to give it was prejudicial error. The Supreme Court, it agreed in part with the Court of Appeal, holding that under the Fair Employment and Housing Act, when a jury finds that unlawful discrimination was a substantial factor motivating a termination of employment, and when the employer also proves it would have made the same decision absent such discrimination, a court may not award damages, back pay, or an order of reinstatement. However, the California Supreme Court also held that the employer does not entirely escape liability. In light of the Act's express purpose of not only redressing, but also preventing and deterring unlawful discrimination in the workplace, the court held that the plaintiff could still be awarded, where appropriate, declaratory relief or injunctive relief to stop discriminatory practice in the future. And if awarded such relief, that also might make the plaintiff eligible for reasonable attorney's fees and costs, giving the plaintiff, in some sense, half a loaf, which is sometimes better than no loaf at all. Now we close with a case involving punitive damages in a health law context. Some 35 years ago, healthcare providers around the country complained that the floodgates of litigation were threatening to overwhelm the healthcare industry. Many states responded with various tort reform measures, including California, which enacted its first major medical liability reform measure known as MICRA in 1975. But MICRA did not settle all of the disputes between the plaintiffs' bar and various institutional defendants. So a little over a decade later, in 1988, as a result of a political compromise between interested parties, which was memorialized on a napkin at a prominent Sacramento restaurant, the so-called napkin deal, the legislature enacted further civil liability reform measures. And included in this package was a statute which bars inclusion of a punitive damages claim in certain actions against healthcare providers unless the plaintiff first demonstrates a substantial probability that he will prevail on the claim. In other words, there's an early pretrial screening process. Well, that demonstration of substantial probability is made by the plaintiff submitting declarations under penalty of perjury that establish the basic facts necessary to support an award of punitives. In Pomona Valley Hospital v. Superior Court, the 2nd District applied this statutory limitation pretty strictly in rejecting the plaintiff's attempt to amend his complaint to add a punitive damage claim against the hospital where the plaintiff's surgery had occurred. The complaint initially pled a garden variety medical malpractice claim to the effect that a first surgery had failed, thereby requiring a second surgery. The basis for the attempted amendment were 3 letters from the hospital's Institutional Review Committee to the doctor who performed the surgery, related to what the letters described as the doctor's, quote, protocol study OP1 putty, close quote. The plaintiff claimed that the letters established that the plaintiff had been subject, without his consent or knowledge, to a secret human subject study. Well, unfortunately for the plaintiff, the letters simply did not fully support that claim. As the court pointed out, the letters did not prove that the study, if any, was the hospital study, as opposed to the individual doctor's study. The letters did not prove that the plaintiff had not been informed of the study, if any, and the letters did not prove that the plaintiff actually had been part of the study. So, at most, the letters established only that the doctor apparently had an ongoing study, but whether it related to the plaintiff was a matter of conjecture. Since the plaintiff's submission did not substantiate the basis for a punitive award, the court ordered the amendment to the complaint to be stricken. Now, as I said before, this is a pretty strict reading of the statutory requirements. It would seem that all of the gaps in the evidence identified by the court are the sort of things that could easily be brought out in further discovery. And the protocol study did appear to involve the same OP1 putty that had apparently been used as part of the plaintiff's surgery. But, strictly speaking, the declarations left clear gaps in the record, so that based only on those declarations, it was not substantially probable the plaintiff would recover punitive damages. This is the sort of case that the Supreme Court could take up because of its importance in medical malpractice liability. My guess, though, is that the court has it right, and that the Supreme Court will leave this one alone. And that's it for today's Kelso Report. Have a great day in the law.